Hello, my name is Dan Dwyer. I'm a lawyer at Kleinfeld, Kaplan and Becker, a law firm in Washington, D.C. I was asked by Professor Card to present to you today some background information on the Foreign Supplier Verification Program. I'm pleased to be presenting today as part of and in cooperation with the Institute for Food Laws and Regulations. The Foreign Supplier Verification Program is an interesting one because it inserts FDA into the day-to-day quality assurance activities of food companies, activities that for many, many years have been considered private activities of individual companies. How is it that FDA gets the authority to regulate in this area? I thought it might be useful to explore this background question relating to the FSVP. And in particular, this concept raised two questions for me. First, how does the FSVP fit into the history of FDA's regulation of product quality and supplier relationships? And second, as I said, where does FDA get the authority to regulate U.S. companies' QA programs for foreign suppliers, as it has done so extensively under the new Foreign Supplier Verification Program regulations? So these are the two questions that we'll explore today as we go through our presentation. And I think what you'll see as we go through this is that the modern concept of the FSVP is based on the old FDA authorities over adulterated food and imported food that have been in place now for over 100 years. Let's look first at adulterated food law. Where does the adulteration authority come from? This concept goes way, way back in history, and in the United States, in modern times, it first became part of the regulation of foods and drugs in the Pure Food and Drugs Act of 1906. In this statute, Congress wrote the principal ideas down about how foods might be in violation of law. That is, they're in violation of law either because they're made in a bad way, their composition is bad, or alternatively, because they're represented in a bad way, that is, their labeling is bad. Now, adulteration, back in 1906, was defined in various ways as having to do with the injurious quality of an adulterated food. So the statute said that a food would be adulterated if something in it injuriously affects its quality, or if there's an added poisonous or deleterious ingredient, or if the food is filthy or decomposed or putrid or otherwise unfit for food. And the statute also had the misbranding concept. That is, the food could be in violation of law because it was improperly represented in its labeling. The 1906 law also regulated imports. And it said that a food can be prevented from importation by the government if it appears to be adulterated. So these three basic concepts of adulteration, misbranding, and import regulation have been part of U.S. food law for over a century. In 1938, these same concepts flowed through into the Food, Drug, and Cosmetic Act, which was enacted at that time and still remains the governing statute today. In that statute, the notion of adulteration remains, and you can see in the statute that foods that contain deleterious substances or filth or are unfit for food are considered to be illegal because they're adulterated. In addition, and very importantly for our purposes as we study the Foreign Supplier Verification Program, the 1938 statute wrote into it the concept that a food could be adulterated because of the way it's manufactured. If it's manufactured under insanitary conditions, it can be adulterated for that reason alone. In addition, the 38 statute continued the old concepts of regulation of misbranded foods and imported foods. With respect to imports, Again, like the earlier statute, the 38 Act said that a food may be prevented from importation if it appears to be adulterated. The 1938 statute gave FDA some new authorities to inspect food manufacturers and to issue regulations, which of course are critical to its modern ability to promulgate Food Safety Modernization Act type regulations, including those for the Foreign Supplier Verification Program. The statutory definition of adulteration, which we'll look at in a few minutes, is a broad one, but a flexible one, in the sense that it was written in relatively vague terms and sufficiently broad to be interpreted in ways that could enable FDA to apply the adulteration concept to different types of products and different types of technologies as they evolved over time. I just wanted to give you a couple of examples here of products in the marketplace that cause the definition of adulteration to evolve over time. The first one was in 1937, the marketing of elixir of sulfanilamide, a drug that was made with diethylene glycol, or antifreeze. It was poison and caused over 100 deaths. And it was an event that, through bad publicity and public outcry, encouraged Congress to change the definition of adulteration, at least in part, by promulgating the new 1938 Federal Food, Drug, and Cosmetic Act to replace the old version of the statute from 1906. Another example was in 1971, Bon Vivant Vichyssoise was marketed. It was marketed in a can, and the can was improperly prepared, causing the product to be contaminated with botulism, leaving one person dead and a number of injuries. This event caused FDA to rethink its good manufacturing practices for low-acid canned foods and similar types of preparations in hermetically sealed containers, and FDA promulgated a new set of regulations to deal with these types of products. So again, these are just two examples of how the adulteration provisions in the statute are sufficiently flexible to permit FDA, using its regulatory authorities under Section 701 and using its general enforcement authorities, to evolve the concept of adulteration to deal with new principles as they come along. Now let's look at the statutory definitions of adulteration. The first is under Section 402A1, which says, "A food shall be deemed to be adulterated if it bears or contains any poisonous or deleterious substance which may render it injurious to health. But in case the substance is not an added substance, the food shall not be considered adulterated under this clause if the quantity of the substance does not ordinarily render it injurious to health." So you can see that this definition focuses on poisonous or deleterious substances and whether or not they're added to the food. An added deleterious substance can cause the food to be adulterated even if it doesn't ordinarily render the food injurious to health. But if the deleterious substance is a naturally occurring one, it doesn't cause the product to be adulterated unless it does ordinarily render it injurious to health. This definition has been litigated over the years. Indeed, it was first litigated under the 1906 Act in the Lexington Mill case in 1914. In this case, the Lexington Mill Company produced flour with a process for bleaching that left a low level of nitrites in the food. And FDA didn't like those nitrites and argued that it may render the flour injurious to health because, after all, bread is consumed by old and young and weak and strong, and there may be somebody within that diverse population of bread consumers that might react badly to the nitrites in this food, causing it thereby to be adulterated. In other words, FDA tried to set a precedent here of reading the adulteration provisions very, very broadly to enable them to go after basically any risk posed by any food. The court rejected that approach, The court said that everything which contains poison is not necessarily poison, and it focused on the notion that in this particular case, the evidence indicated that the risks to consumers caused by these nitrites were very, very small indeed. The court said that the phrase may render it injurious to health in the statute is to be interpreted in its natural and ordinary sense, where there's no possibility of harm under a reasonable consideration of all the facts. The food is not within the ban of the statute. And this articulates the principle that de minimis levels of adulterants, de minimis levels of risk under the statute are not actionable. And so it sets up for FDA and for food companies a difficult conundrum, which is how do you know when the level of adulterant in your food is significant or de minimis? Significant levels of adulteration can be a violation of law, which can be very serious, but de minimis levels can be no violation at all. And drawing a line between those two levels of adulterants is not always an easy process, and it's not made any clearer by the vague terms of the statute or the vague terms of most of FDA's regulations. The second definition of adulteration under the statute that we want to look at is in 402A3, which says, a food shall be deemed to be adulterated if it consists in whole or in part of any filthy, putrid, or decomposed substance, or if it is otherwise unfit for food. This case involving green coffee beans illustrates how this definition works. In this case, there was a shipment of imported coffee that had been damaged by water and had 15.1% moldy coffee beans. It wasn't very appetizing, but it could be safely consumed. FDA disagreed that it was an appropriately imported food and argued that the food was adulterated because it consists in whole or in part of any filthy substance and is otherwise unfit for food. In this case, the district court said, well, no, you could still drink the coffee. It wasn't very appetizing, but it was still fit for food and therefore wasn't adulterated within the meaning of this restriction. The Fifth Circuit disagreed and sent the case back for further study, thinking that, well, the law here defines any, quote, filthy food as being adulterated, and therefore this food might be adulterated on that principle. And furthermore, the mold level in this case was above FDA's informal tolerance of 10%, suggesting that at least the administrative agency with expertise in this area had made a determination that this particular type of food wasn't fit for food because of the mold level. Filth present in trifling amounts is not an adulterant. So, as we saw in the first case involving a situation with nitrites in flour, we also see in the case involving filth. If you've got a product with a small or de minimis level of filth, including insect parts below levels that might be considered objectionable by FDA, those levels do not cause the product to be adulterated. And finally, we want to look at the definition of adulteration under Section 402A4. And this is the most important definition for our purposes when we look at the Food Safety Modernization Act and the Foreign Supplier Verification Program. This definition says that a food shall be deemed to be adulterated if it has been prepared, packed, or held under insanitary conditions whereby it may have become contaminated with filth or whereby it may have been rendered injurious to health. This is a very broad definition, as you can see, and it's got some vagueness packed into it that renders the definition very powerful. It doesn't specifically say what insanitary conditions are, but it does say only that the product involved does not have to have been contaminated with filth, but may have been contaminated with filth or may have been rendered injurious to health in order to be adulterated. So there's some open-endedness to this definition that makes it a very broad and powerful provision in the statute. Beginning in the 1960s, FDA began to try to write some more detail around these vague provisions of Section 402A4 when it began to promulgate its good manufacturing practice regulations relating to foods. So in 1967, FDA proposed regulations on current good manufacturing practice to, quote, interpret the insanitary conditions provisions of Section 402A4. These were regulations that would apply to all foods generally, and they were finally published in 1969. And these general regulations on food GMPs have been with us ever since, only being changed very recently under FDA's new Good Manufacturing Practice regulations as part of the Food Safety Modernization Act. In addition, in the 1970s, FDA began to promulgate specific GMP regulations for specific foods. And these are interesting to look at because they begin to do some of the same things that you see FDA doing in the Foreign Supplier Verification Program and in the supplier controls written as part of FDA's hazard analysis and critical control point regulations. So, for example, some GMP rules at the time addressed purity of raw materials before their entry into the manufacturing process. FDA said for low-acid canned foods that raw materials needed to be inspected for microbiological contamination. For cacao products and confectionery, milk and eggs needed to be pasteurized to destroy salmonella. For bottled drinking water, the water supply needed to be monitored for purposes of checking the water that became placed into the bottles. And for smoked fish, there were time, temperature, and salinity requirements for the processing of the incoming raw materials. These various different specific GMP regulations began to take effect, and FDA began to enforce them. And in some cases, manufacturers pushed back against them, which caused some litigation that helped to define the principles under which the good manufacturing practice requirements apply. This is just one example. In 1977, FDA's smoked fish regulations were enforced against the Nova Scotia Food Products Company, and the company objected, saying that FDA's regulations went beyond its statutory authority. The company argued that the definition in the statute of insanitary conditions, which referred to conditions whereby the food may have been rendered injurious to health, refers only to insanitary conditions in the plant itself, and it does not cover processing conditions necessary to destroy pre-existing microorganisms in the food. In other words, the company was arguing that if our plant doesn't insert insanitary conditions into a food, but merely prevents insanitary conditions from being destroyed that were pre-existing, then we're not in violation of 402A4. The court disagreed with the company and agreed with FDA here. The court argued that, or stated that, the language of the statute should not be read too restrictively, but rather as consistent with the Act's overriding purpose to protect the public health. FDA rulemaking authority under Section 701A is broad, the court noted, further supporting the lawfulness of the GMP regulations promulgated here. And under 402A4, the court noted that a food does not have to become contaminated during processing in order to be adulterated. It only needs to have been rendered injurious to health by inadequate sanitary conditions of prevention. So, if a fish comes through the door of a smoked fish plant and contains salmonella, it's not necessarily adulterated at that point. But if that smoked fish plant fails to take steps to prevent the salmonella from growing or fails to kill the salmonella adequately, then those can be insanitary conditions causing the product to be adulterated. The Supreme Beef Processors case was a similar type of case in which beef processors challenged the USDA's regulations that purported to restrict the kinds of meat that was coming through the door of meat facilities. In that case, the court said that insanitary conditions does not cover regulating the microbiological content of incoming raw meat materials, but it only covers what happens in the plant. The court in Supreme Beef Processors specifically said that its finding was intended to be consistent with the finding in the smoked fish case. Now, FDA's Good Manufacturing Practice regulations, promulgated in the 1960s and 70s, largely stayed unchanged for many, many years. But what didn't change was the industry's development of manufacturing practices and review processes to ensure that manufacture of food was safe. One of the concepts that manufacturers developed to build more effective food safety systems was the Hazard Analysis and Critical Control Point, or HACCP program. These began in the 1960s, and they were intended to be a process whereby hazards were first identified and critical control points during the manufacturing process were regulated so as to reduce those initial hazards. And in 1986, FDA decided to make HACCP optional as part of food GMPs and wrote them into 21 CFR section 110.80. HACCP programs were later made mandatory by FDA for seafood and juice and other foods, and also made mandatory by USDA for meat and poultry. Over the last 20 years, private audit systems have evolved, led mostly by food retailers who've been focusing more and more on supplier quality and wanting consistent, effective, and low-cost means of evaluating supplier quality. So food retailers have developed programs to evaluate supplier quality systems, and these have included things like the Global Food Safety Initiative, launched in 2000, and the Safe Quality Food Certification Program, launched in 1994, which have been intended to build private audit systems to ensure that there's consistent standards being applied across the industry to the various different suppliers of food for retail stores and retail consumers. FDA's Good Manufacturing Practice regulations are written in a non-specific, vague, and open-ended way, and it's difficult to know by reading the Good Manufacturing Practice regulations exactly what kind of manufacturing behaviors would cause a product to be inconsistent with the regulations in any specific case. And so the best way of knowing how FDA's Good Manufacturing Practice regulations are meant to be implemented can be seen by looking at FDA's enforcement actions in its warning letters and inspectional observations. And so here, in this next couple of slides, I've put a couple of examples of warning letters to show how FDA has interpreted its requirements and the regulations for sanitary conditions. In this warning letter for Santos, for example, which dates back to 2012, FDA discussed standards for insanitary conditions. For example, they cited Santos for equipment that was not properly cleaned or sanitized, for employees who didn't properly wipe equipment and utensils, for employees who didn't wash their hands properly, for work surfaces that were not properly constructed and couldn't be adequately cleaned and sanitized. So these types of sanitary conditions are just examples of the kind of thing that FDA looks for when it goes out to audit. You won't see these specific examples in FDA's regulations, but these are the kinds of specifics that FDA looks for purposes of implementing the general provisions in its regulations. In addition, you won't see, at least in FDA's regulations that have been used for the last 30 years, specific rules having to do with environmental testing of listeria. But in fact, as you can see from enforcement actions like this warning letter to Famous Amos back in 2011, FDA does rely on environmental testing showing listeria as being evidence of adulteration. In this particular case, FDA said that 15 environmental swabs showed a listeria isolate that was, quote, indistinguishable from environmental samples collected by FDA at your facility back in the previous year. FDA concluded that this caused the product to be adulterated because although your finished product cookies may not support growth of listeria, the positive swabs are indicators of insanitary conditions in your facility and demonstrate a failure of cleaning and sanitation operations. Perhaps the most famous in recent years example of a company that has been proceeded against and enforced against based on insanitary conditions is the Peanut Corporation of America. This company was accused of shipping a number of products containing salmonella, resulting in a number of deaths and hundreds of recalls of downstream products produced with their peanuts. In 2009, FDA held a press call to discuss its inspection of the company and some of the observations that it had made of the company's procedures. It said at the time that GMP deficiencies are related to cleaning programs and procedures, as well as failure to implement steps to mitigate salmonella contamination. It further said that the firm's own internal testing program identified salmonella contamination in a product, and after getting a subsequent negative test result, sometimes using another lab sample, the firm shipped finished products. So you can see that in this enforcement action, again, FDA is adding on to the principles embodied in its GMP regulations and the principle of insanitary conditions embodied in Section 402A4 of the statute to require steps to mitigate salmonella contamination and adequate, above-board, non-misleading testing of salmonella in a food facility. So let's summarize some of the key points of adulteration law that contribute to and provide a foundation for the Foreign Supplier Verification Program. First, insanitary conditions can cover sanitation deficiencies, microbiological contamination, inadequate processing, inadequate testing, as we saw in the PCA example, that may render the food injurious to health, and this can cause a food to be adulterated. The food does not need to be actually injurious to be adulterated under Section 402A4, under the insanitary conditions provision. It only needs to be made under such conditions. The food that's made under such conditions is adulterated as a matter of law. Now, the corollary to that, as we discussed, is that there's a de minimis exception, that is to say, filth in trifling amounts or insanitary conditions in trifling amounts are not necessarily an adulterant. The trick is to know the difference between when conditions are trifling or de minimis on the one hand and significant on the other. Naturally occurring microorganisms on incoming raw materials are not necessarily adulterants, but if the facility's processes are inadequate to eliminate those microorganisms, they can give rise to insanitary conditions. And finally, the presence of microorganisms in the environment can be by itself an indicator of adulteration due to insanitary conditions, even if those microorganisms never, in fact, or can't be proven to, get onto the food itself. Now, with that as background on the adulterated food side, let's turn now to look at the imported food law. There's a long history of FDA regulation of imported foods. I've traced it back as far as the Tea Importation Act of 1883, but the statutes probably go back further than that. In this statute from 1883, Congress established uniform standards of purity, quality, and fitness for consumption of imported tea. The statute was challenged in the case of Butfield versus Stranahan, and the Supreme Court said that Congress has a police power to exclude merchandise at discretion. So the Supreme Court upheld the Tea Importation Act and the authorities under it, saying that the power to regulate commerce with foreign nations is expressly conferred upon Congress, and being an enumerated power is complete in itself, acknowledging no limitations other than those prescribed in the Constitution. Further, the court said it was competent for Congress by statute to establish standards and provide that no right should exist to import teas from foreign countries into the United States unless such teas should be equal to the standards. So you can see that from the Supreme Court's perspective, the tea statute was fine because of Congress's extraordinarily broad power to regulate imports. This constitutional power flows through into the Food, Drug, and Cosmetic Act in Section 801, where Congress empowers FDA, the Secretary of Health and Human Services, to exclude imports if it appears from the examination of such samples, that is, samples of imports, or otherwise, that such article has been processed under insanitary conditions or is adulterated or misbranded, then such article shall be refused admission. Now, this Section 801 language is very broad and gives to FDA quite extensive authority to restrict importation of foods that are subject to its restrictions. So, for example, if you look at this provision, you can see that insanitary conditions is separate from the notion of adulteration or misbranding. And so FDA can say that if an import is made under insanitary conditions, then it may be refused, even if it has not yet reached a conclusion that those conditions are enough to cause it to be adulterated or misbranded. Further, Section 801 restrictions provide that an import can be restricted, quote, if it appears to have been processed under insanitary conditions. So we don't even need a final determination from FDA that insanitary conditions apply. FDA only needs to conclude that, quote, it appears that insanitary conditions apply, and that's enough to enable it to restrict an import. FDA's import law in Section 801 has been the subject of some litigation as well. One of the more famous cases is Sugarman versus Forbrag from 1968, another case involving coffee beans. In this case, the importer of coffee beans challenged FDA's order excluding the materials from import under Section 801. The importer argued that the order is subject to judicial review under the Administrative Procedure Act and that it should be vacated if the beans were not, in fact, adulterated. What was the result here? Well, the court found for FDA. The court said, if it appears, that is to say, the statutory phrase, if it appears, which appears in Section 801, suggests discretion to be tested by a standard of arbitrariness rather than error. While the superficiality of tests or an arbitrary refusal to accept their results may be appropriate subjects for judicial review, a dispute as to what an examination has established or disclosed is more appropriately left to agency expertise. The issue here, the court said, is not whether imports are adulterated. The issue is whether they appear to be, and any reasonable basis that FDA has for determining appearance is lawful. Moreover, the court said, there is no judicial review required under the Administrative Procedure Act, as importation is, quote, committed to the discretion of the Secretary. So the upshot of this analysis of the statute by the court is that FDA's authorities under Section 801 are extraordinarily broad. FDA may interdict an import before any adjudication that it's made of adulteration or misbranding. If FDA determines that an import appears to be made under insanitary conditions, then it may be restricted. This provides a powerful set of authorities under which FDA can promulgate regulations such as those in the Foreign Supplier Verification Program. Now, in the next few slides, I'd just like to comment on some of the other statutory authorities that you can find in the law that are relevant to and provide some precedent for Foreign Supplier Verification Program regulations recently promulgated by FDA. Looking first, for example, at the meat laws and regulations. The Federal Meat Inspection Act says, no carcasses, meat, or meat food products shall be imported into the United States if such articles are adulterated or misbranded, and unless they comply with all the inspection, building, construction standards, and all other provisions of this chapter and regulations. This statutory provision was implemented by USDA in its equivalence rules, rules that state that imported meat must meet all U.S. safety standards. Foreign countries may employ sanitary measures that are different from those in the U.S., but they must be equivalent and provide the same level of protection against food hazards as achieved in the U.S. So this concept of equivalence, which arises in the meat inspection statute and regulations, can also be seen in the requirements of the Foreign Supplier Verification Program. Now, in the Foreign Supplier Verification Program and in the Food Safety Modernization Act generally, Congress amended the Food and Drug Act at Section 421B to provide some additional authorities and requirements for FDA when inspecting imported food. And you can see in these requirements the kinds of authorities that Congress was thinking about for purposes of authorizing the Foreign Supplier Verification Program. So FDA has to inspect to evaluate the safety risk of the food, the safety risks of the exporter and importer, the effectiveness of the Foreign Supplier Verification Program, whether the importer participates in the Voluntary Qualified Importer Program, whether adulteration is intentional, whether the import is certified, etc. These kinds of inspectional requirements are a new aspect of the statute that provides a separate type of authority for the Foreign Supplier Verification Program. That is to say, it implements the notion of a risk-based foreign inspection program under which the Foreign Supplier Verification Program will proceed. And finally, I wanted to mention the Public Health Service Act. The Secretary under the Public Health Service Act is authorized to make and enforce such regulations as are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries into the states or from one state into any other state. So this too provides statutory authority for the kinds of regulations that FDA has promulgated in its Foreign Supplier Verification Program. Now, in addition to the U.S. statutory authorities and precedents that we've discussed that underlie the FSVP, you can also see that the goal of the Food Safety Modernization Act was that the FSVP be consistent with requirements of international law as well. The FSVP is specifically required not to be inconsistent with the WTO and other treaties, and Codex, a UN organization, which is recognized by the WTO as being the International Standards Organization for Food Safety, specifically includes, under Codex guidelines for food import control systems, restrictions or provisions that sound very similar to those of the Foreign Supplier Verification Program. So Codex guidelines state that countries may set their own protection levels for imports. It states that standards should be based on risk and applied consistently to imports and domestic products. And it states that supplier verification systems may be appropriate. So you can see that this kind of international law requirement looks a lot like and probably gave rise to the Foreign Supplier Verification Program concept in the Food Safety Modernization Act. So the FSVP was signed as part of the Food Safety Modernization Act, in 2011 added in Section 805, so it's part of FDA's import restrictions under the 800 series section of the statute. The FSVP requires the same level of protection as under the preventive controls regulations or produce safety rules. It requires compliance with adulteration and allergen labeling rules. It requires a risk-based approach. In other words, FDA's Foreign Supplier Verification Program in its regulations has a statutory foundation in Section 805. In addition, the statute implemented provisions in Section 301 stating that it's a prohibited act to import without FSVP compliance, and it implemented in Section 801A that an imported food must be refused if it appears that there's a violation of FSVP rules. So the statute works as an integrated whole now with respect to the FSVP. So to conclude, considered in a historical context, you can see that the Foreign Supplier Verification Program is a type of import restriction program that's generally consistent with precedent on adulteration and import controls. That is to say, it's based on a foundation of FDA's long history of regulation of and restriction of imported foods generally, and it's consistent with the kinds of definitions of adulteration, and it's consistent with a long history of import controls. But also the Foreign Supplier Verification Program goes beyond the historical practice to require a new level of detail in how importers are required to assure safety. And finally, I wanted to close with these quotes from my favorite Food and Drug Law case, U.S. versus White. This case was a Supreme Court case that was considering the appropriateness of criminal conviction of a president of a company who was convicted because their company violated the food and drug laws, even though that president himself did not have any personal knowledge or intent that the company violate those laws. The court said in response to the challenge by this corporate president, the purposes of this legislation touch the lives and health of people which, in the circumstances of modern industrialism, are largely beyond self-protection. Regard for these purposes should infuse construction of the legislation if it's to be treated as a working instrument of government and not merely as a collection of English words. Such legislation dispenses with the conventional requirement for criminal conduct, awareness of some wrongdoing. In the interest of the larger good, it puts the burden of acting at hazard upon a person otherwise innocent, but standing in a responsible relation to a public danger. Well, now, with the Foreign Supplier Verification Program, the FDA is extending its reach and extending the reach of these concepts that were articulated in the White case to the shores of foreign countries and companies who are supplying U.S. producers of food with ingredients, or U.S. retailers and importers with finished foods. Well, thank you very much for your attention today. I appreciate your listening, and I hope you enjoy the rest of the class.